So here we go right here. Calendar for Tuesday, July 14th, 2026. And y'all can see 10 a.m. right here. Pre-trial conference defended Durk Bank's motion to sever counts or any alternative to dismiss third superseding indictment on speedy trial grounds. Wilson joined her, Lindsay joined her. So yeah, these guys are in on it as well. You want to know how the feds and the judge are, in my opinion, in cahoots? If I write you a 19-page letter and you only fire back with 6 and you do it within a couple of hours when I fire off my 19, that means you already had it in writing as far as what you thought I was going to say and you were ready to go. But a preemptive strike means what? That you care or you don't care? I'll let y'all be the judge of that one. Take a listen to this here because Durk got court today. The feds firing back. They fired back last night, but I just was in the funk. I ain't feel like reading all this shit. But anyways, supplement to government's opposition to defendant Banks' motion to sever counts or in the alternative to dismiss the third superseding indictment on speedy trial grounds, exhibits 2 through 4. Now, let's go ahead and see what the hell they're talking about. Memorandum of points and authorities. The government files this supplement to correct certain factual assertions in defendant Banks' reply and to provide a more fulsome record for the court. First, defendant Banks incorrectly states that a forensic examination report of co-conspirator Force iCloud was first produced on June 28, 2026, attached as Exhibit 2 is the government's discovery letter documenting the production on December 10, 2025 of the entire forensic image of co-conspirators Force iCloud, along with over 35 other seized devices and /or accounts. See Exhibits 2 at 12/10/25, discovery letter at FBI 302 documenting the production. Notably, the government made this production to accommodate a request made by defense counsel to examine the full image of all digital devices and accounts seized by the government. Exhibit 2 at 1, USAO cover letter noting that the production was made at defendant's request. To the extent defendant believes the subsequent June reproduction of material contained in the iCloud contained a plethora of Brady and Gilgio, that material was available to defendants in October 2025. Second, the government did not shrink its responsibilities under the pretrial schedule. Following the return of TSI on June 3rd, the government sent numerous communications to defense counsel seeking clarity about the trial date and pretrial deadlines to provide a more fulsome record to the court. That QR code is going to unlock Taco Tuesday for y'all by adding 10 in your account. So all you got to do is start playing games and increase that whole entire thing, man. Free cash, setting names. You like the new Shaq and Kobe, peanut butter and jelly. Get yourself in today. Don't wait on it. Just hit that QR code and tap that link in the description. Free cash, setting names. Let's get to the content. Hold on. Forensic report. We ain't tripping on that there. The government attaches as Exhibit 3 the remainder of the email thread attached as Exhibit K to defendant Banks' filing. Exhibit 3 documents that the government circulated a proposed stipulation modifying the pretrial briefing schedule and asking for authorization for e-signature, to which only counsel for defendant Houston responded. Moreover, attached as Exhibit 4 is an email thread in which the government solicited defense counsel's position on a continuance. In the exchange, the government noted that its trial exhibit list and motions in limine were a function of which defendants in which charges would be proceeding to trial, if any, on August 20th. Yeah, but y'all know that's not going to happen, so I don't even know why they bullshitting us. But whatever. In response, defendant Banks' counsel responded that they were prepared for an August 20th trial as of now. The counsel for defendants Wilson and Lindsay represented that they would be prepared for an August 20th trial should the court grant one or more of the pending severance motions. Third, contrary to defendant Banks' claim that his multiple explicit past assertions of his speedy trial rights are clear from the record, the defendants, including Banks, caused the prior continuances. Defendant Banks requested the initial 11-month continuance to October 2025, and he took other steps to delay this trial. For example, on November 13, 2025, defendant Banks filed his motion to disqualify all Central District judges and the United States Attorney's Office, which explicitly asked this court to vacate the scheduling order, including the January trial date and calendar motions that were set for hearing on November 18, 2025. After the court entered a minute order the following day, making it clear that it would not stay the proceedings. Defendant Banks filed a written objection, asking again to stay the proceedings and vacate all dates. When the court declined to stay proceedings, defendant Houston, Wilson, and Lindsay requested a trial continuance because the court would not vacate the scheduling order. Finally, as set forth in the government's opposition, defendant Banks has failed to justify the extraordinary relief he is requesting. While defendant Banks' reply asserts that a further continuance will be lengthy based on conflicts of other defense counsel, he does not indicate how much time he will request, if any, should the court deny either of the pending motions. I think the feds forget y'all controlled the pace. Y'all did the illegal shit. Y'all didn't even prosecute the people. Okay. So if y'all recall, right, the feds said, oh, there was threats made by people who are inside of Lil Durk's camp to the judge and to the prosecution and all that crap. And then the feds went and studied and found out it was nothing but some goddamn fans who more than likely were white suburban kids. They never told that to the damn prosecution, while the judge had been threatened, pardon me, and then the damn judge was the one who made the ruling that we weren't going to get a bond because of one of the reasons being the threat. So the feds are full of shit. They just are. But here's the funnier part. Just because they put in those motions does not mean that the feds have to dictate and can dictate what a damn speedy motions process is. That's part of the damn reason. And they couldn't address none of this shit. None. As I'm reading it, I'm like, bro, hold on. Because I do take notes on this shit. So I had to sit back and go, golly. We're talking about people who basically were not going to explain the main points. The main points were emails sent out late. Y'all were under the presumption that we were going off of what the hell y'all wanted to do. Y'all brought the case to us. It's up to us to have a speedy trial. I think it's the Sixth Amendment. So, no, feds, y'all full of shit. And this is how you know it's full of shit, because it's 19 pages to 6. If you argued, and let's say you argued that a certain superhero was the best superhero, and you put up 19 arguments, don't you think that it would be better if Sadie Nash said, you actually don't have the best superhero, and the 19 arguments that you put up, I only talk about 6 of them? We're not going to even talk about the other 13? There were motions in there talking about how they purposefully delayed shit, how they had certain things already set up, and the feds just said, we just going to ignore that shit. But this is how I know that the judge is on side with the prosecution, because the judge ain't going to say anything about this shit. The judge is only going to do this, guaranteed. I could damn near put money on it, because what time is it? Okay, so it's 9 o'clock over there. The judge is going to mess around and say this stupid ass shit. You guys need to come up with a schedule to do these things, and I'm issuing a stern warning for you to produce 404B and all of this shit immediately. But immediately means after you reviewed everything. It's not when y'all get it, then y'all send it over. No. It doesn't work that way. Don't be surprised if you see more charges added onto this Vicar. Don't. And once again, because they pointed it out, so we can point it out here too. There are threads and threads and threads of evidence that does not include Lil Durk. They're bringing up shit that doesn't matter, and that's part of the severance that Lindsay and all of them were trying to get on. Like, hey, bro, this ain't got shit to do with us. And in retrospect, it really doesn't have shit to do with Durk, but your lawyers can't argue that. Your lawyers have to argue for their clients only. See, your lawyer can't go, yeah, and Lil Durk didn't do this. No. Your lawyer goes, oh, shit, no, for my client, it's this, and this. And if it's something good enough, Lil Durk and them will join on to the motion. But that's that. We're sitting at a threshold where we get to dictate and determine certain things. And what we dictate and determine is simple. The feds are full of it, and we know it. So the question is, what happens next? Durk goes into court today, 10 o'clock on the West Coast. We will see. It'll probably be about 3 hours or something like that. Y'all check out I'm Not a Lawyer, but because she'll be dropping it. I'll read specifically from her Instagram. Shout out to her. Shout out to her family. Shout out to everybody up over there. But yeah, man, I'm not falling for the shit. And if y'all go, nah, Nash, that's BS, man. Hell nah. Let me make the argument myself. Gotcha. Click right here to see the full entire read of it, or click right here for the playlist, and I will catch y'all in the next one. Reload it!